Good evening, gentlemen. I'm sure we all had quite an awesome day. All right, so welcome to tonight's online session. I still remain your host, O.O. Stevens. And tonight we are going to be looking at the topic constitutional safeguards in criminal litigation. And the constitutional safeguard, we are going to be taking a voyage through section 36 of the Constitution. We are going to be looking at the rights that an accused is entitled to. We are going to be looking at the likely exceptions of such rights, and we're also going to be looking at the effects of the absence of such rights. In other words, we are going to be having a little review of section 36 of the Constitution, because that is the section that talks about fair hearing. That is the section that encompasses the rights that a person who has been arrested or a person who is standing trial is entitled to. And we are going to be taking the first right, which is that the accused has a right to be informed of the crime that is being alleged against him. He is entitled to be informed of the crime that is being alleged against him. You can see section 36 sub 6a of the Constitution. Section 36 sub 6a of the Constitution. And this right is to the effect that the accused is to be informed promptly during his arrest or arraignment in the language that he understands of the details and nature of the offense for which he is charged. And where he does not understand the language of the court, he shall be provided with the services of an interpreter at no cost to him. At no cost to him. Now, note that failure to inform the accused of the nature of the offense he is charged with will vitiate the trial. If the accused is not being informed of the nature of the offense that he is alleged to have committed, that can be a ground to vitiate the trial. And if you can actually blend this with your understanding of the rule against ambiguity in charges, you will appreciate that in the acronym of ADPOPs, you will notice that telling the accused the name of the offense that he has committed in the charge sheet is one of the primary things that has to be contained in a charge sheet, an absence of which there is no exception. So an accused has to be informed of the nature of the offense that he has committed. And any breach of this particular provision will render the trial a nullity. Any breach of this particular provision will render the trial a nullity. And let us look at, are there exceptions to this particular right? Yes, there are exceptions. One of the exceptions is when an accused is caught in the act of committing the offense. If I catch you while you are stealing my yam, I don't need to tell you that you are being arrested for stealing yam, because you were caught while you were committing that said offense. Also, he can be convicted for a lesser offense flowing from the offense he is actually charged with, and he is deemed to have had notice of it. Now, what this means is, for instance, a person can be charged for rape, but at the end of the day, the court may end up convicting him for attempted rape. But in the charge sheet, there is no place that the offense of attempted rape is contained. But what this means is that once he has been charged for a particular offense, he can be charged for committing an offense lesser than that offense. He can be convicted, despite that lesser offense is not contained on the charge sheet. Please note that he can only be convicted for a lesser offense, not charged. Not that he can be convicted for a greater offense, no. So in other words, if somebody is charged with attempted rape, he cannot end up being convicted for rape, since there is no rape stated as a count in the charge sheet. So a person who is charged for a particular offense, the law is that such a person can be convicted of an offense lesser than that particular offense, though that particular lesser offense was not contained in the charge sheet. Remember, we said that he has a right to be informed of the offense that he's been alleged of. And we now said now that where he is caught in the act, he cannot be informed of the offense again because he's caught in the act. And we also said that he can be convicted for an offense that is not being communicated with in the charge sheet, but that offense that he's to be convicted with has to be lesser than the one with which he was charged. All right, let us look at the next right. We have right to fair hearing. We have right to fair hearing. You can see section 36 sub 1 and 4 of the Constitution. Now, this particular right of fair hearing is also known as the principle of natural justice. It's also known as the principle of natural justice, and it is captured under two pillars. Now, the two pillars are the two Latin maxims that are well known. Even from your year one in the university, you should be aware of the Latin maxim known as nemo judes in causa sua. Please, the spelling is judes, Judex, but the pronunciation is Yudes. So nemo judes in causa sua. What nemo judes in causa sua means is that somebody cannot be a judge in his own matter. And we also have the next pillar, which is the pillar of ordinarium partem. Ordinarium partem means that a case cannot be determined in the mouth of a single party. In other words, there is a need for us to hear from the other party involved before the court can effectively determine the matter. So those are the two pillars of natural justice. Now, with respect to the nemo judes in causa sua, you should note that what this means is that justice is not only expected to be done, but it has to be seen to have been done. So in other words, once you have an interest, you the judge has an interest in any of the parties or the subject matter or even the outcome of the proceeding, you will be required to recuse yourself from presiding over the matter. The reason for this is to avoid any bias and for there to be a picture of transparency seen in the entire proceeding. And ordinarium partem, this means that a person is entitled to be heard by the court before he will be convicted. A person is entitled to be heard by the court before he will be convicted. But in this principle of ordinarium partem, are there exceptions? The answer is yes, there are exceptions. And what are the exceptions of ordinarium partem? One is where the accused has willfully chosen to remain silent during his trial or defense. So assuming after the prosecution has closed his case and the accused still remains silent and he doesn't want to talk, so the court can go ahead and do the needful in that particular instance. And on such, the accused cannot wake up and say that he has been denied of his right to fair hearing because he's the one that willfully chose to remain silent. Also, where the accused refuses or ignores to attend proceeding. For instance, now you are being summoned, maybe by your school Senate board, and you refuse to go, and you have actually been served. And when you refuse to go and they notice that your refusal is maybe out of malice or something else, they can go ahead with the proceeding and do the needful. And you cannot come back later and say that you were denied right to fair hearing because you were not heard. Also, another exception is where there is an ex parte application. Where there is an ex parte application, I believe by now you know about motion on notice and motion ex parte. So ex parte application means motion ex parte. And you know that in motion ex parte, the other party is not to be communicated. In motion ex parte, the other party is not being informed. So when it is a motion ex parte that has been established by the law, you cannot wake up and say that in this motion you are not communicated. No, because the law said that that type of application has to be by way of motion ex parte. Now I want us to briefly look at the concept of publicity of trials. It's still under the principle of fair hearing, but it is not one of the pillars. Now, publicity of trial, this is the effect that a trial has to take place in a public place, that members of the public will not be denied unfettered access into the venue of the proceeding. And also, when judgment is to be given, such a judgment has to be given also in public. In other words, there is no place for trial in privacy. However, there are some exceptions to publicity of trial. For instance, where it is in the interest of justice, where it is in the interest of public safety, where it is in the interest of public morality or public defense, trial may be held in private. Also, where it concerns the welfare of a person who has not attained the age of 18 years, trial may be held in private. Also, where a young person is to give evidence in a case that involves morality, trial can be held in private. Also, where a minister or commissioner satisfies the court that it will be in public interest for the matter to be held in private, then such can be held in private. There are very many other exceptions to the concept of publicity of trial. And the issue of publicity of trial still falls under the principle of fair hearing, in as much as it is not one of the pillars. The two pillars of natural justice are audiotarem partem and nemo iudes in causa sua. And we have discussed the two, and we have said that nemo iudes in causa sua means that one cannot be a judge in his own matter, meaning there should not be any element or likelihood of bias that is seen in the course of the proceeding. And we also said that the issue of audiotarem partem has to do with the other party must be heard, meaning that the court cannot effectively determine a matter before it without hearing both parties. And we have also discussed that there are some exceptions to the principle of audiotarem partem. All right, let us look at the next right that the accused enjoys. There is something known as right to the presumption of innocence. Right to the presumption of innocence. This right is contained in section 36 sub 5 of the Constitution. Section 36 sub 5 of the Constitution. An accused is presumed innocent until he is proven guilty. And I believe by now we are aware that the burden of proving the guilt of the accused is on the prosecution. The burden of proving the guilt of the accused is on the prosecution. And the judge is not expected to say or write anything that is pointing to the suspect's guilt, that is pointing to the guilt of the accused. And it is worthy of note that if there is any doubt that is raised in the mind of the court with respect to the proceeding, such a doubt has to be resolved in favor of the accused. If there is, please, we are using accused here in a generic term. We are using accused in a generic term. Immaterial the jurisdiction, we are using accused here in generic term. So now, where there is any doubts in the mind of the court as regards whether this young man is innocent or guilty, that doubt is going to be resolved in favor of the accused. That is why the standard of proof in criminal matters is beyond every reasonable doubt. So if there is still a doubt in the mind of the court that is very reasonable, then such a doubt will be resolved in favor of the person who is standing trial. Now, are there exceptions to this right of presumption of innocence? Yes, there are exceptions. One of the exceptions is that the accused is to prove facts that is within his own special knowledge, such as defense of insanity, alibi, intoxication. So if maybe during trial you said, okay, if you are the one that killed him, but you were under the influence of alcohol, now you are now trying to establish to us that there is a fact that is within your own knowledge. So it is no longer the job of the prosecution now to disprove anything. The prosecution has already proved that you killed this person. So since you are now trying to say now that you were under the influence of something, or you have any special defense that you want to rely on, maybe defense of insanity, defense of intoxication, defense of self-defense, or anyone. So once you are having any defense, that means that there are facts that are within your own peculiar knowledge, and it is expected of you now to be the one that will prove those facts. I believe by now we are aware of the two burdens of proof. We have the legal burden of proof, which is the one that we say does not shift from one party to the other. It always remains on the prosecution. And we have the one called the evidential burden of proof, which is the one that swings. It can come to this man, it can come to this man. So I believe, so our understanding of the evidential burden of proof is going to make us appreciate this that we are discussing now, that when there are facts that are within the purview of the accused special knowledge, then it's expected of him to prove it. However, we have said earlier that the general rule is that it is on the prosecution to prove the guilt of the accused. But if the accused has any defense, then it is on the accused to prove such defense. Now, the next exception is where a convict is appealing against his conviction. He is no longer presumed innocent. For instance, now if a trial court had already convicted you, then that right that you enjoy about being presumed innocent, you are no longer innocent because you are now a convict that have been convicted by a court. So if you are now appealing against the judgment of that trial court, you will not be appealing against that judgment as a person who enjoys any right of innocence presumption. No, you are appealing as a convict who is now begging the appellate court now to overturn the conviction. So you don't enjoy any right that is contained in section 36 sub 5, which is right of presumption of innocence, you don't enjoy it again when you are appealing against a decision that is made that is not to your favor. All right, let us look at the next right, which is right to adequate time and facilities for his defense. Right to adequate time and facilities for his defense. This is contained in section 36 sub 6b of the Constitution. Section 36 sub 6b of the Constitution. Now, the time we are talking about here relates both to the first day that the case was slated and any other subsequent date that reasonable adjournment may be required by the accused. So, in other words, the court, even if after the first day the court granted him the time to prepare for his defense, he is still expected to enjoy that particular right throughout the trial. So, for instance, if there is a witness that he needs in the court and the witness is not around, he may tell the court that his witness is not available and the court is expected to grant him adjournment. But before the court will grant such an adjournment, the accused must satisfy the court that 1, the witness is material to his case. So if the court must grant you adjournment for the absence of your witness, you must show the court that the witness is very material to your case. Also, that you have not been guilty of negligence in procuring the witness. In other words, you cannot come and be telling us that the witness was not in court when you never informed anybody that you want him to come and stand as witness for you. Such, the court is not going to grant you any adjournment because you are not seen to be serious. And also, there is reasonable expectation that you can procure the witness on the next adjourned date. So if the court grants you adjournment now, are you guaranteeing the court that on the next adjourned date, you must make sure that the witness is available? And you must also prove to the court that they have not been granted other adjournments in earlier dates to procure this same witness and you refuse to. So all these things are the things that the court has to satisfy itself with before the court can grant you adjournments with respect to procuring your witness. And also with respect to preparation for your case, anything that has to help with the proof of evidence in your case, the court will reasonably look into it and see whether to grant you adjournments with respect to preparing more for your defense, because you are still presumed to be innocent. And anything that is likely to maybe hinder the flow of your defense or hinder the success of your defense, the court is definitely not going to be a party to that. Now, if an accused is standing trial for murder or any capital offense, he is not represented by counsel, the court must ensure that one is provided for him. So where you are standing trial for the offense of murder or any other capital offense, please, murder is not the only capital offense. And I believe that you know by now that capital offenses are offenses that carry death penalty. So murder is not the only offense that carries death penalty. Felony also carries, treason and treasonable felony also carries death penalty. So where you're standing trial for murder or maybe treasonable felony and you don't have any person as a counsel representing you, it is expected of the court to guarantee and to make sure that you have a counsel representing you. That is it. Now let us look at the next right. We have right to a counsel. Right to a counsel is contained in section 36 sub 6c of the Constitution. Right to counsel is contained in section 36 sub 6c of the Constitution. Now, a party cannot be denied the right to counsel of his choice, and neither can a counsel be imposed on him if he chooses to defend himself in any court, so long as it has nothing to do with murder or capital offenses. Now, what this means is that if I have chosen that A is going to be my lawyer, the court is not duty bound to tell me that A cannot represent me so long as A does not suffer from any legal disability. So A can represent me. And nothing also stops me from representing myself. However, the law is to the effect that where it has to do with capital offenses, I cannot be allowed to represent myself because of the technicalities and the sensitive nature of such matters. Now, in Uzodinma versus COP, the court declared as null and void the provision of section 390 of CPCL and provision of section 28 of Area Court Edicts, where legal personals are denied audience in the area court. What this is talking about now is, in section 390 of the Criminal Procedural Code Law, that is CPCL, and Section 28 of Area Court Edicts, that is the law that established area courts. It is to the effect that lawyers cannot appear before the area court. Lawyers cannot appear before the area court. And when this matter was brought before the court in the case of Ozodimma versus COP, that is Commissioner of Police, the court looked at this very cursorily and was to the opinion that this particular provision of the law has contravened Section 36 sub 6c of the Constitution that gives that gives a party right to have a counsel that would present in any court. On that, the court now declared the provision of Section 390 of CPCL and Section 28 of Area Court Edicts to be null and void. And I believe by now we are aware that where there is any law or any enactment that is in contravention with the Constitution, it shall be, to the extent of its inconsistency, be declared null and void. So any particular law that says that a lawyer cannot appear before a particular court, that particular law is seen to be contravening Section 36 sub 6c of the Constitution. Now, are there exceptions to right to counsel? Yes, there are. And what are the exceptions? 1, senior advocates of Nigeria shall not appear before inferior courts. Once somebody is a senior advocate of Nigeria, this one now is one of their privileges and the guidelines. So once you are a senior advocate of Nigeria, you cannot appear before inferior courts. And somebody would ask, which courts are inferior courts? Inferior courts are those courts that you don't see when you open Section 6 sub 5 of the Constitution. Any court that you do not see in Section 6 sub 5 of the Constitution that is named there, any court you don't see there is presumed to be an inferior court. Like magistrate court is an inferior court, area court is an inferior court, Sharia court is an inferior court, customary court is an inferior court, but customary court of appeal is not an inferior court, because customary court of appeal is a superior court of record. Is a court of record, meaning that it is a court that is on record, is a court that is written down in the law. So if you want to really know the courts that are superior courts, you go to Section 6 sub 5 of the Constitution. Any court that you do not see there is presumed to be an inferior court. And the law is that senior advocates of Nigeria cannot appear before inferior court. They cannot appear before courts that are not stated in Section 6 sub 5 of the Constitution. And such in itself is not in contravention of any constitution. This was held in the case of Ekwa versus Ijesha. Ekwa, ECWA versus IJESHA, Ijesha. Now, the next exception is that a counsel shall not be granted audience by the court if he is subject to any legal disability. For instance, a person that has not paid his practicing fees can be denied right of audience in any court. For instance, now if you're arguing matter with the other lawyer and you know that this particular lawyer has not really paid his practicing fees and you are very sure about it, you can raise it before the court that counsel has not paid his practicing fees, therefore he is not entitled to right of audience in the court. And when you raise such and you are very correct, then such a counsel cannot be granted right of audience, and such is one of the exceptions to your right to have a counsel. The next exception is that an accused may choose to represent himself in non-capital offenses. Remember, we are discussing right to counsel, so he can choose not to exercise that right to a counsel where it is with respect to a non-capital offense and it has to do with him wanting to represent himself. So those are the exceptions with respect to Section 36 sub 6c of the Constitution, which talks about right to a counsel. And let us look at the next right, which is right to examine prosecution witnesses. Right to examine prosecution witnesses. You can see Section 36 sub 6d of the Constitution. Every person who is charged with a criminal offense shall be entitled to examine, either in person or by legal practitioner, the witnesses that are called by the prosecution. So if I am being arraigned now and the prosecution called witnesses, then there is a need for me to examine such witnesses. I believe by now we know about the concept of examination in chief, cross-examination, and re-examination. And we said that when the adverse party is the one that is questioning a witness, then that is called cross-examination. But when the party that brought you to court is the one questioning you, that is called examination in chief. And after cross-examination, and maybe there were some ambiguities that were raised during your cross-examination, the party that brought you to court can still question you again, and that one is called re-examination. So this right is the effect that the accused can cross-examine the prosecution witnesses. Now, when the court gives the accused the opportunity to examine and he does not, he cannot later appeal to state that he was denied the right. So where the court now asks him, counsel, do you have any question for the witness? And he said, no, my lord, I don't have any question for the witness. And the court now decided to tell the witness to step down. You cannot, during appeal, you will now say that, my lord, I was not allowed to cross-examine this witness. Therefore, my rights has actually been breached. So long as it can be shown that you were asked to cross-examine and you refused, then you cannot wake up again and say that you were denied that particular right. Now, are there exceptions to this particular right? Yes, there are exceptions. And what are the exceptions? One, if the accused or his counsel ask irrelevant questions. If you ask questions that have no bearing with the issue on the table, the court can deny you asking the witness such a question. Also, questions that are meant to harass a witness. Questions that are meant to harass a witness, place a witness in unnecessary tension in the witness box. The court will disallow that because a witness that is in court is coming to help the court with the cause of justice. So, and the court will not allow you to harass a witness unnecessarily with your legal jargons or legal threats. So, such would actually be denied you by the court. And also, where the prosecution called no witness. So, if the prosecution didn't call any witness, then you will not have any person to cross-examine now. It's as clear as that. So, where the prosecution did not call any witness, then you will not be cross-examining anybody. So, those are the exceptions to the right of examining the prosecution witnesses. Now, let us look at the next right, which is right to an interpreter. The next right is right to an interpreter. You can see section 36 sub 6E. Section 36 sub 6. Remember, I told you earlier that we are taking a voyage through section 36 of the Constitution. So you can see section 36 sub 6E talks about right to an interpreter. Now, if an accused does not understand the language of the court, then he must be provided with an interpreter at no cost to him. And that interpreter must be competent in both languages. The interpreter must be competent in both the language of the court, which is English language, and language of the accused, which is the native language. He must be very, very competent. And the interpreter is expected to interpret whatever is said by the accused line by line. So he doesn't have to wait until the accused finishes stating his own part of the story before the interpreter will now come and summarize it with what he remembers and what he does not remember. Such will not actually be allowed. And the court must ensure that the interpreter has no relationship with any of the parties and also has no connection with the case. So that interpreter must be a very objective and impartial interpreter that probably has not met either the accused or any of the parties for the first time, except that day that he is doing the interpretation. This is because there has to be a very gross likelihood and picture of unbiasedness seen in the entire proceeding and process. Now, are there exceptions to this right to an interpreter? Yes, there are. One of the exceptions is where the accused understands the language of the court. Then there will be no requirement for an interpreter. When accused understands what the court is saying, then there is no need for him to have an interpreter. And also, where the accused never stated that he does not understand the language of the court. So if you never told the court, even for one, that you don't understand the language of the court, then the court is not the Superman to know that you don't understand its language. So such will fall under the exception. And let us look at the rights to only one trial for an offense. I believe by now most of us have heard about what is called bar pleas. Bar pleas. Right to only one trial for an offense. You can see section 36 sub 9 of the Constitution. Now, no person who has shown that he has been tried earlier by a court of competent jurisdiction and either acquitted or convicted will be tried again on the elements of the same case. This brings us to what I believe all of us know, that is known as autrefoy convict and autrefoy acquit. So where you show that you have earlier stood trial and that particular trial led to your acquittal, nobody can bring you back to court again on the elements of the same case involving the same parties and involving the same circumstance. Nobody can bring you again to court. If anybody does that, then you can raise this defense of autrefoy acquit. And when you can also show that you have earlier been tried by a court of competent jurisdiction and you have been convicted and you are done serving your sentence, nobody can bring you again on the elements of the same case to stand trial. If such happens, the law allows you to raise a defense known as autrefoy convict. Now, are there exceptions to this? Yes, there are. One is where there is an appeal. For instance, now, if you are acquitted and the other party felt aggrieved and decided to appeal, you cannot come to appellate court and you'll be telling the appellate court, my lord, the trial court had already acquitted me. No, because appeal means I want the court to review what the trial court actually came to as its decision. So an appeal is an exception to the defense of autrefoy convict or autrefoy acquit. And also where there is an order of retrial. For instance, now the appellate court may notice some sort of irregularities in the procedure and the appellate court still does not believe that it can be a ground for you to be allowed to go. So the appellate court can order the trial court to try the matter again. Such is known as order of retrial. So if there is an order for a matter to be retried, you cannot be capitalizing on the fact that you have earlier been tried and acquitted or convicted. All right, let us look at the next right. We have right against trial and conviction on a retroactive legislation. Right against trial and conviction on a retroactive legislation, section 36 sub 8 of the Constitution. Now, no person shall be held to be guilty of a criminal offense on account of any act or omission that did not at the time it took place constitute an offense. And also, no penalty shall be imposed for a criminal offense heavier than the penalty in force at the time of the offense. For instance, if an offense is committed now and there is no particular law at that particular time that the offense was committed that is against the offense, and maybe in the long run a law was now made after the offense was committed, you cannot be trying me on a law that was made after I had already committed an offense, because such is not one of the spirits of the law. And also, you cannot convict me for a penalty or with a penalty that is more than the penalty that is in force. Assuming if the penalty said that the highest punishment for armed robbery is 14 years, highest punishment, that is maximum punishment, is 14 years, you cannot be sentencing me to death for armed robbery. If you do that, then it would be against the letters of the law. That is the implication of section 36 sub 8. Now, this section has two particular aspects, meaning that the person is not to be punished for an act which is not an offense when committed, and also a person shall not be penalized with a punishment that is more than the one that was in force as at when the offense was committed. All right, let us look at the next right. We have right to be tried for an offense known to law. Right to be tried for an offense known to law. I believe most of us are aware of Aoko versus Fabemi. It is like the mantra of this particular principle. Right to be tried for an offense known to law, section 36 sub 12 of the Constitution. A person shall not be convicted of a criminal offense unless that offense is defined and penalty prescribed in any written law. I believe you remember that in the case of Aoko versus Fabemi, adultery is stated to be a crime in the north, but adultery is not a crime in the south. So if you sleep with somebody's wife or somebody's husband in the north, you can be charged under the penal code because it is written down expressly that this is what? A crime. But if you sleep with somebody's wife or husband in the south, such is not a crime because there is no written law that penalizes such a particular act. That is the implication of right to be tried for an offense known to law. It has to be written down, and also the punishment must be expressly stated. And it is worthy of note that the conviction under a repeat law stands because when the offense was committed, it was an offense known to law. For instance, now you committed an offense now, and there is a law that is against that offense now, and your trial starts, and maybe at the end of the day your trial was concluded in 3 years' time, and in that 3 years' time there is already another law that has come to repeal this particular law that was in force when you committed the offense. The law is that you will still be convicted under that repeat law because that was the law in force when you committed the offense. All right, let us look at the right against trial for an offense already pardoned. When we talk about pardon is to the effect that a person has been convicted and either the president or the governor grants him pardon. A person has been convicted and either the president or the governor grants him pardon. So there will be no pardon when there is no conviction. Please note, because you may be asked to state the difference, not necessarily law school though, but maybe it can come up maybe in your day-to-day argument, the difference between amnesty and pardon. Amnesty is forgiveness granted to a person that has committed an offense before the person is tried. So there is no trial in amnesty. Amnesty is that you are known, that it is known that you are the one that did this, but the government still say no problem, we have forgiven you. So there was no trial. But when there is a trial and there was a conviction and the government forgives you, that is called pardon. So pardon only comes in when there was a conviction. I would want you to know that. And also, somebody that has even finished serving his sentence can also be pardoned. And I believe that you know that once you have served a sentence, you are known as an ex-convict. And if you are not pardoned, there are some disabilities that are hovering over your head. That is why it is important that when you are not granted pardon, those disabilities are now removed from you. For instance, you can contest for an election. For instance, you can do very many other things. So pardon can still be granted to you even if you have finished serving your sentence. I want you to know that. So for instance, now there was an offense that you committed and you were convicted, and please, it is only the president or the governor that can pardon. The governor for state offenses, the president for federal offenses. The chief judge or the chief justice do not grant pardon. And the chief judge and chief justice, when they go to prison for decongestion, they don't have any business with people that have been convicted. Their business are with those that are awaiting trial. I want you to know that. So it is only the president and the governor that has a business with those that have been convicted. If you hear that the chief judge of a particular state is going for prison decongestion, if you have ever followed the delegation to go with him, you will notice that his business are only with those that have not yet been convicted. He doesn't touch the case file of those that have been convicted. And if you notice the delegation of the governor that is coming for that is coming for pardon, or the one called prerogative of mercy, when they come, they don't have any business with those awaiting trial. Their business are with those that have already been convicted. So I want you to know the difference between in whose jurisdiction is pardon and in whose jurisdiction is granting release to those awaiting trial. And I also want you to know the implication of a pardon. When you have been pardoned, every legal disability that is hovering over you would actually be removed. And I also told you that even if you're done serving your sentence, you are still an ex-convict. But when you have been granted pardon, you are no longer an ex-convict. That is the implication. So, and assuming you're still serving your sentence and the president or the governor, as the case may be, pardons you, you are no longer to be seen or regarded as an ex-convict. And now, when you have enjoyed a particular pardon and you are now being rearrested on the elements of the same matter again, you can be showing them by the authority of section 36 sub 10 that you have been granted pardon on this particular offense, and therefore you cannot be rearrested or even to be tried again on this offense. And I told you the effect of such a pardon. All right, let us look at the next right. We have right to silence. We have right to silence. The accused has a right to silence. This is contained in section 36 sub 11 of the Constitution. Section 36 sub 11 of the Constitution. No person who is charged with a criminal offense shall be compelled to give evidence at his trial. No person. So once you have been charged with a criminal offense, you cannot be compelled by the court to give evidence. Such does not happen. And this right to silence is at the point of opening defense. This right to silence, you only enjoy it when the accused has closed his case. This does not mean that you are not speaking in the court. No, it doesn't mean you are not talking. It only means that you are not bringing up a defense to your case. Now, I want you to note that the silence of an accused person upon arraignment is not the same as the silence here. Upon arraignment is when you are brought to take your plea. When you choose to remain silent, the court has a different role to play. And the role is to inquire into the reason for your silence. If it is out of malice, or the court will have to require, because it could be that you are silent standing mute, or that you are silent that you refuse to plea. If you refuse to take your plea, the court can actually record a plea of not guilty for you. But if you are silent and is that you are standing mute next to the effect that you are not saying anything, you are behaving like a deaf and dumb person. So the court will inquire into the reason for that your muteness. And if it's out of malice, the court will enter a plea of not guilty for you. And if it's if it's as a result of an act of God, which is maybe you became dumb overnight, the court shall remand you in prison custody pending the pleasure of the governor. But the silence we are talking about in section 36 sub 11 is different. It is the silence that you enjoy. This one now, you enjoy it, is your right. The law says you cannot be compelled to talk. The court cannot compel you to enter a defense if you don't want to enter a defense. So if the prosecution is done with his case and you choose not to open your defense, that is said that you are enjoying your right to silence. And nobody can compel you. Nobody can compel you to put away these particular rights. However, the court is entitled to comment or to draw necessary inference from the accused person's silence. So the court can infer that your silence could be to any particular type of effect. But the prosecution cannot comment that your silence to give evidence means that you have admitted to being guilty. The prosecution cannot open its mouth and tell the court that because this young man has refused to open his defense, that means he has admitted that he is guilty. That is contained in section 181 of the Evidence Act. So the prosecution cannot comment that the reason for your silence is admission to guilt. Such is not being allowed. But the court, remember, can make inferences. Now, this right may avail an accused where it is manifestly clear that the prosecution has failed to prove his case. So if it is clear now, you say that I killed somebody, you cannot provide the person I killed before the court, you cannot even tell us the name of the person I killed, you cannot even link me to anything that has to do with murder. So such is manifestly clear that you have not been able to prove the elements of murder. And if you cannot be able to do that, I can exercise this right to silence. But remember, this right to silence, it has effects, and the effects are: one, it means implied admission of being guilty. You are impliedly admitting. And where you remain silent, it means that you are resting your case on that of the prosecution, and you must accept liability or responsibility for anything that comes out from the conduct of the prevailing circumstance. And it is risky for you to hold on that right, mainly when you have any defenses to your advantage. So it is risky for you to exercise this particular right, assuming you have defenses that you can raise that can help to either mitigate or to even render the case of the prosecution to become nugatory. All right, on that, we're going to be drawing the curtain on this topic. We have taken a little voyage into section 36 of the Constitution, and we have seen the various rights that a party can enjoy. We have seen the effects of each of those rights, and we have also seen the exceptions of those rights. Our lecturers can also do, or will also do, associative justice to this particular topic. And until we meet again, I will ask you all to take care of yourselves and do have a great night.